alienation is real. It occurs, and in appropriate cases, the court will make findings about unacceptable risks of harm associated with parental alienation. Time for another case summary. In this video, we'll be talking about a recent 2025 case, a judgment, where the court made a finding that one of the children were at an unacceptable risk of harm due to the father's conduct and behaviour, amounting to an unacceptable risk of alienation, so turning the child against the mother. So in this case, the court made orders to increase the mother's time with the child, and there were other restrictions placed on the father. For example, that he was only allowed to send certain messages to the child during the mother's time, and he was to provide the mother with a copy of text messages or correspondence that he sent to the child during her time. It's the case of Ball and Ball, No. 8, 2025. You can view the entire judgment for free using Ostley. In this video, I'm simply reading from the judgment. So there were 3 subject children: child X, born 2008, child Y, born 2009, and child Z, born 2012. Child X lived with the father, child Y lived with the mother, and effectively child Z lived with the father and was spending limited time with the mother. The parties are all 3 children's mother and father. There was an independent children's lawyer that had been appointed and who appeared in the proceedings. The parties married in 2009 and they separated on or about 26 July of 2021. At 7, the judgment and the court says, the parties have had an extremely high conflict relationship which has severely negatively impacted all 3 children. So the mother was the applicant and she was seeking more time with the child Z. So there had been several allegations leveled against the mother, and the court explained in the previous judgment that there had been an 8-day judge-alone trial in relation to the allegations against the mother. The mother had been acquitted in the district court proceedings. They were an 8-day judge-alone trial. So mum's saying, that's a significant change in circumstances. I should be given more time with Z. The settled reasons for the decision of His Honour of the District Court of New South Wales had been received, and as a consequence of the dismissal of proceedings and receipt of those reasons, a single expert report from Ms. S, dated 14 May 2025, had also been received. So that was considered during these proceedings to help the judge make its decision. It is finally common ground that all charges have been dismissed with written findings by the learned district court judge, and no appeal or other charges had been filed or heard. The father's primary position was that a further interim hearing should not be allowed given the number of interim hearings to date, and he said that there has been no relevant change of circumstance warranting a revision of the interim arrangements. The essence of the father's submission is that the mother has engaged in an attempt to wear him down and there is no material change of circumstances, and that even if not ideal, the current interim orders constitute a satisfactory holding pattern. Now reading from paragraph 30, the mother relies on the learned district court judge's findings that the court also notes the previously mentioned issues in relation to the inconsistencies in and between his 3 versions, his demonstrated bias towards and his father's dislike of his mother after the breakdown of his parents' relationship, his willingness to make specious allegations to police in terms of his mother's compliance with the AVO she was subject to, the inconsistencies of his claiming that he omitted matters from the second JERT interview because of threats made to him by his mother, notwithstanding that in that very JERT interview, he alleged for the first time that his mother had indecently him when he was 10 or 11 years of age. Having carefully taken into account the directions previously articulated in these reasons, the submissions of the Crown Prosecutor relating to why the court would accept the evidence of X, the child, as being honest and reliable, and the submissions of senior counsel to the contrary, I am not satisfied that X, so the child was called X in the district court proceedings, was an honest and reliable witness, such as would allow me to be satisfied beyond reasonable doubt that the touching in the manner and circumstances described by X and relied upon by the Crown to substantiate count 22 actually occurred. In relation to the credibility of the accused, the court notes the Crown and defence submissions in relation to her evidence. The court paid particular attention to the accused as she gave evidence. She was appropriately emotional when questioned in evidence in chief and when cross-examined by the Crown Prosecutor. The accused made admissions against interest in relation to a number of photographs and acknowledged that her voice could be heard in a number of the videos. The accused was consistent in her approach, both in chief and in cross-examination. The evidence that she gave was internally consistent. She appeared to the court to be horrified at the suggestion that she had deliberately created child material. She consistently and strongly maintained that the photographs represented family members at times recorded humorous moments or were taken for medical purposes, or to refute Mr. Ball's claims that she was a bad mother who did not properly look after her children. I found the accused to be an honest and reliable witness, and I accept her evidence that she did not indecently the child as he described, end quote. And that's from the district court proceedings. So mum's saying, hey, significant change in circumstances. I've been acquitted. They found me to be credible. This is relevant to the family court proceedings. I want more time. 31, the court says that evidence is relevant where there is no appeal and no other outstanding matters. That finding may be given weight where the trial judge saw X, the child, saw the mother, viewed the images, which I have not seen, and dismissed all charges and made those findings. At para 33, this is admissible in parenting proceedings, including in a final hearing, and although obviously not binding upon me, where another judge has had the benefit of seeing the mother and viewing all of the material and has made those findings and the charges have been dismissed, although there is, of course, a very different criminal standard involved, nevertheless, reading that judgment as a whole, there is nothing in it which would sustain the allegation of unacceptable risk of harm which had been made against the mother, which had also impacted her time with the child to date in the family court proceedings. Para 39, the court says, of course, Miss S's opinion, so she's the one who did the report, the expert report in these proceedings. The court says, it's untested, but so is all of the evidence at this stage. Remember, these are interim proceedings. And whilst there is no magic in a family report or a single expert report, it is another piece of relevant evidence which, on the face of it, is considered and discloses careful reasoning. Paragraph 40. Given the history of the matter and the father's position, I consider it worthwhile setting out some substantial aspects of the report. So I'm about to read some paragraphs that are quoted by the judge in the judgment that have been taken from the expert's report. Remember, the experts can be social workers, psychologists. They're engaged to review material, meet the children, observe the child or children with the parents, and to prepare a report to the court which can help the court making decisions. So it says, Z, remember the child is Z in these proceedings. Z was interviewed individually at the home of his father and was also observed in the company of his siblings with his father and with his mother and siblings the following day. When interviewed separately, he was abrasive and overtly negative towards his mother. He recounted numerous anecdotes about her various shortcomings and described events as though he had been personally present, including commentary about child support, school fees, allegations of presentation. The child's presentation conveyed a negative litany about his mother. He aligned closely with his father and child X when speaking about her and appeared to be swept up in the collective negativity. However, when observed in his mother's company, his presentation changed markedly. When alone with her, he was calm, engaged, and warmly interactive. When accompanied by his siblings, he remained neutral and resisted being drawn into negative discussions. Despite the emotionally charged atmosphere, he appeared attuned to his mother's distress, particularly in response to the behaviour of X, the other child, and to a lesser extent Y. Notably, at the time of departure, when his siblings were not present, Zed gave his mother a long, lingering and affectionate hug. He was unaware that I observed. You see the difference between the behaviour and what some alienated children will spurt as their coach to say, or as they think that the person alienating them wants them to stay. This is often where alienation is picked up in family law matters, where you have an expert who's able to hear what the child is saying, but also observe their behaviour, which might not be consistent with their words. The contradiction in Zed's behaviour is significant. When interviewed individually at his father's home, he used the pronoun we to describe his concerns about his mother. He spoke in vague generalities about bad stuff that his mother had allegedly done to them, including her involvement in court proceedings and a criminal trial which she got off. He expressed the view that the judge's decision was unfair, that more witnesses should have been called, and that the judge had failed to understand the full picture, thus reaching the wrong conclusion. Despite this criticism, Zed did not describe any specific behaviour from his mother that had frightened him or caused him personal harm. Nevertheless, he continued to speak negatively about her, claiming that she had tricked Y into saying untrue things so that Y would live with her. He described ongoing conflict between his parents, attributing its initiation primarily to his mother, especially regarding work-related arguments. Zed, who previously described Ms. D as gentle, intelligent, and affectionate boy, remains triangulated within the family conflict. When interviewed at his father's home, he displayed strong alignment with his father's narrative. Of particular concern is that Z is starting to show signs of alienation from his mother. He spoke about her in a manner devoid of ambivalence, repeated borrowed narratives beyond his developmental capacity, and demonstrated knowledge of adult matters, such as about finances, child support, and legal proceedings. Despite this, my direct observation of Zed with his mother was that he displayed affection, sought comfort, and engaged warmly with her. The stark contradiction between his behaviour with his mother and his verbal reports, while the father is conspicuous and must be understood as an outward representation of being trapped between conflicting parental narratives. Paragraph 41. These direct observations and descriptions of Zed's behaviour are suggested of alignment with the father, of behaviour intentionally seeking to align Zed by the father, but also suggestive that Zed is in a position where he is still willing to engage with and warmly interact with the mother. So the relationship may be saved. Because remember, there's degrees of rejection. So they might have caught this child just in time before he had completely rejected the mother. It is important to apply these findings to the allegation that Ms. Ball is a offender and that she offended against her own children. The history and presentation of Ms. Ball reflects nothing of these considerations. She is not low functioning. She does not come from a chaotic, impoverished, low socioeconomic background. She has no reported history of trauma, does not present with severe psychiatric illness or personality disorder. She conveys a high capacity to reflect upon the emotional needs and experiences for children. She's capable of having reciprocal adult interpersonal relations as she currently enjoys, and there is no suggestion that the alleged offending occurred in the context of a coercively and controlling relationship where she felt compelled to do so. Her presentation does not fit with the typologies identified. Significantly, the description provided at the time, the initial reports were that she engaged in this behavior towards X for her own sexual gratification. Although the available studies suggest that motivation is not what motivates offending in this group of women, but rather that their offending stems from their emotional needs, including loneliness, dependency, and unresolved trauma, none of which applies to Ms. Ball or her presentation. The expert went on to say, notwithstanding the allegations, the inescapable conclusion is that the post-separation parenting relationship between Mr. and Mrs. Ball has been marked by extreme conflict. The social science literature is replete with evidence regarding the short and long-term adverse consequences for children exposed to escalating and persistent parental conflict following separation. In short term, children exposed to ongoing parental conflict are more likely to exhibit emotional dysregulation, heightened anxiety, fear, sadness, behavioral issues, aggression, defiance, withdrawal, academic difficulties, problems in peer relations, including diminished pro-social behavior and increased social withdrawal or hostility. In the long term, these children face elevated risks of chronic internalizing disorders such as depression, anxiety, and low self-esteem, externalizing problems including conduct disorders and antisocial behavior, impaired attachment, security, particularly with the parent perceived as emotionally unavailable or hostile, difficulties forming and sustaining intimate relationships in adolescence and adulthood, and poorer life satisfaction and mental health extending into early and middle-aged adulthood. Children have been reported to perceive their parents' conflict as threatening, with the involvement of children in loyalty binds or triangulation exacerbating harm done to them. 7, and that children's sense of safety and emotional stability is significantly undermined in high conflict environments. Parenting quality often deteriorates in the context of sustained conflict, with increased hostility, reduced warmth, and inconsistent discipline mediating many of the observed developmental harms. As such, the damage to the children's well-being is not only a direct result of conflict itself, but also the conflict's corrosive effects on parental responsiveness and family functioning. The social science research clearly and unequivocally states that exposure to parents' high conflict places children at significantly heightened risk for anxiety, depression, substance abuse, and difficulty in forming and sustaining reciprocal, satisfying, intimate relationships in adulthood. These findings are clearly relevant to the present dispute and relate directly to all three children. The court says at paragraph 42, I note the acquittals, the full reasons, and the findings of an experienced district court judge who has seen the alleged material, CSA material, the child and the mother, and the expert's opinion, and also taking into account Zed's age and self-protective capacity at almost 13, all satisfy me that there is no evidence which would justify an interim finding that there may be an unacceptable risk of harm of unsupervised time between Zed and the mother. The expert said if it is found that Zed is not at a risk of harm in the mother's care, then he should be spending more time with her. Although he has stated a preference for the current arrangement to continue, his strong alignment with his father must influence that view. When observed with his mother, he appeared relaxed, affectionate, and engaged. Whilst in one sense there is ample justification for Zed to spend equal time with each parent, a shared care arrangement may embroil Zed directly amidst his parents' conflict to his detriment. The alternatives for X to continue to reside with the father and continue with alternate time, weekend time with his mother, or alternatively, him to reside with his mother and sister with a temporary suspension of time with the father, followed by a graduated reintroduction of contact on alternate weekends and during school holidays. Concerns regarding the emerging parental alienation lend support to him residing with his mother and seeing his father and brother. So in parental alienation cases, that's what the court often does, is swap residence. So takes it away from the parent who's alienating the child, that is often deemed unacceptable risk of psychological harm, place it with the safe parent who is not alienating the child, suspends time with the alienating parent, and tries to reintroduce the relationship between the child and the healthy parent or the safe parent without interference from the other parent. So that's what the expert had kind of indicated here. The expert went on to say, a clear distinction emerged in the presentation of each parent. Mr. Ball's narrative was dominated by criticism of Ms. Ball, with a focus on blame, past grievances, and perceived injustices. In contrast, Ms. Ball's primary concern appeared to be the welfare and emotional well-being of the children. In this regard, she demonstrated a markedly greater capacity to reflect on the children's experiences, to identify the psychological risks they face, and to respond empathetically to their needs. Mr. Ball displayed a notable lack of empathy and attunement, particularly with respect to the psychological impact of these proceedings on Y. Ms. Ball appears better able to respond to at least the children's emotional needs. And then it says, families entrenched in high conflict litigation place children at considerable risk of long-term psychological harm. Children exposed to such dynamics often resort to splitting as a coping mechanism, viewing one parent as all good and the other as all bad. This form of binary thinking reflects a state of psychological crisis and lays the groundwork for future relational difficulties. Prolonged litigation is likely to deepen these divides, reinforcing rigid perceptions of good versus bad, safety versus danger, and truth versus lies. Based on my assessment, Ms. Ball does not present a risk to Zed. On the contrary, it is my view that Zed should be spending significantly more time with her than he presently does. However, it remains unclear whether Zed should tolerate an equal shared care arrangement. Imposing such an arrangement may place him in an intolerable loyalty bind with potentially damaging psychological consequences. It is also uncertain whether he would be able to maintain meaningful relationships with both parents under such conditions. If he continues to reside primarily with his father, it is possible that his relationship with his mother will deteriorate. Conversely, changing his living arrangements may provide the best opportunity for preserving his connections to both parents long term. So basically, if dad's not able to foster that relationship between the child and mum might be better able to do so if she was the primary carer. Ultimately, a testing of evidence may shift the balance of concern slightly in favour of one parent over the other. Until that time, the focus should remain on what arrangement best supports the developmental and emotional needs of Zed while protecting him from further psychological harm. Families entrenched in high conflict litigation place children at considerable risk of long-term psychological harm. Children exposed to such dynamics often resort to splitting as a coping mechanism, viewing one parent as all good and the other as all bad. This form of binary thinking reflects a state of psychological crisis and lays the groundwork for future relational difficulties. Prolonged litigation is likely to deepen these divides, reinforcing rigid perceptions of good versus bad, safety versus danger, and truth versus lies. Based on my assessment, Ms. Ball does not present a risk to Zed. On the contrary, it is my view that Zed should be spending significantly more time with her than he presently does. However, it remains unclear whether Zed should tolerate or could tolerate an equal shared care arrangement. Imposing such arrangement may place him in an intolerable loyalty bind with potentially damaging psychological consequences. It is also uncertain whether he would be able to maintain a meaningful relationship with both parents under such conditions. If he continues to reside primarily with his father, it's possible that his relationship with his mother will deteriorate. Conversely, changing his living arrangements, living with mum instead of dad, may provide the best opportunity for preserving his connection to both parents longer term. So sometimes where there's evidence that a parent is unable to foster a relationship between the child and the other parent, sometimes the court will say, well, if the other parent's better able to do it, let's let them do it. They might be the better primary parent because they might be able to ensure the child does enjoy that relationship with both parents. Paragraph 44, the judge said, "In that regard, I give significant weight to the expert's opinion that," and I quote, "it may be reasonably argued that his greatest risk is psychological alienation from his mother, not abuse from her," end quote. I again acknowledge this is untested, but the principles of an interim hearing require me to consider the evidence, and although I cannot make findings, I must do my best to weigh and balance it. Para 70. As I have said, I consider there is no unacceptable risk in the mother's household. I think there is a risk of alienation. That is where the balance lies. There can be no firm findings. I do not know what will happen on a final hearing, but balancing all of those issues and noting the other provisions which I must consider, I do not see any issues of physical or psychological safety in the mother's household. 72. Para 72. I do consider there is a risk of psychological injury if Zed becomes alienated. So, what orders did the court make? Order 5 and 6 of the orders dated 23 December 2024 be varied as per Order 2 below. Child Z shall spend time with his mother as follows. For a period of 3 visits each alternate weekend from Friday after school until Saturday after soccer is concluded, or midday if there is no soccer scheduled. So an increase in time. At the conclusion of time in Order 2A, for a period each alternate weekend from after school on Friday or 4 p.m. if a non-school day until 5 p.m. Sunday. Order 3. The time in Order 2 shall continue throughout the school holidays unless otherwise agreed between the parents. Order 4. Notwithstanding any other order, Z shall spend time with the mother from 10 a.m. Christmas Eve 2025 until 2 p.m. Christmas Day 2025. The father, this is an interesting one. The father is restrained from sending more than one text message each day to Z while Z is spending time with the mother, and with a copy of the message to be provided to the mother at the time it is sent. Order 6. The changeover location shall be at the school Z attends at the location that Z is playing soccer, or otherwise as per Order 6 of the orders dated 23 December 2024 if changeover is occurring on a non-school day. All parties' costs are reserved. In the past, I've had people comment on my videos suggesting that alienation isn't real. Now, you can see from this case that experts and the court will use the term alienation, and sometimes it will make findings about alienation in appropriate cases. It is very much a real thing. I've done lots of videos on the topic of alienation. Some experts won't use the label. They'll simply describe the behaviours that a parent will engage to turn the child against the other parent, which can constitute psychological harm and abuse. And so it is a real thing. It does happen. And you can see in this case, the expert used the term alienation. It's used multiple times throughout the judgment. And it resulted, the mother was successful in her application for more time. The court made a finding of fact in relation to PA. Content of this video is a single case summary. It should not be relied on as legal advice. As always, I'm a lawyer, but I'm not your lawyer. If you're going through a separation, very important to obtain legal advice tailored to the unique circumstances of your case.